think we're pretty much all here, so I will kick off. Welcome, everyone. Thank you so much for coming along today, despite the tube strikes and any other barriers you might have faced. We're really pleased to welcome you here today to Herbert, Smith, Freehills, Kramer. We've got a great panel and hopefully a really interesting topic. We will be running through various topics that we've thought about, but obviously to the extent that anybody has any questions or there are any points you're particularly interested in, we hope to have some time at the end for questions. So my name's Emma Deas. I'm a partner in the banking litigation team here at Herbert Smith Freehills Kramer. I will be moderating this panel today, although no doubt everyone will be very well behaved. I am joined by Simon Hanif KC from 3VB, who is an expert in sanctions and who we have worked with extensively, and our guest from KK&P. So we have Oleg Kolotilov and Nikolay Pokryshkin, who are joining us today and will be able to speak to some of the Russian law angles, and our senior associate, Alexander Gridasov, who will be walking us through some of those points and some of the English law points as well. So we're here today to talk about sanctions, Russian sanctions, actions in Russia. Sanctions has become a significantly more, I won't say significantly more interesting, a significantly more high-profile topic in the last few years, of course. Used to sit on our compliance checklists, and now it is a day-to-day issue that we all deal with. There's been some really interesting cases, a lot of questions about when can parties pay, when can parties not pay, what do we do with our contractual obligations, are they suspended, are they unenforceable, and where should our disputes be heard, which will be a key topic that we are talking about today. The English courts have done a lot to grapple with these issues. They are difficult, they are commercially significant, and we need to think about how does sanctions legislation work in this country? How do we interpret that? What happens to our payment obligations when performance is prohibited by UK, EU, or US sanctions, or one or multiple of them? When is foreign illegality or public policy going to prevent us making payment, and what protection do we have in that situation? There's been a lot of English court activity, as I've said. I think from our perspective, we have seen the court take a broad and purposive approach to sanctions, but they also pay close attention to those contractual provisions and what is required. So we'll talk a little bit about that further today. At the same time, we've seen some very active Russian responses, a lot of parallel cases happening in Russia. Russian parties are increasingly launching cases in Russia, notwithstanding arbitration clauses which refer to the English jurisdiction or clauses which refer to the English courts. We've seen a lot of anti-suit injunction activity, and we've seen some very substantial penalties as well. So we're going to talk a little bit about that today. We're seeing further developments in Russia, including attempts to structure Russian judgments in a way which makes them easier to deploy outside of Russia, and some use of Russian insolvency proceedings. So a lot to talk about, a lot to think about. As I say, I hope it's engaging, and to the extent you have any questions, happy to speak about that at the end. So Simon, maybe we can kick off by talking about the English law picture and some of the cases and interesting case law that we've seen come out in the last few years and months.
Thanks so much, Emma. And great to be here, everyone. So I'm going to talk about two cases in particular which have come out very recently. The first case I'll talk about is a Supreme Court case which came out in May 2026, which is the Celestial Aviation case. So just to give you a very sort of potted overview of the facts, and they can be succinctly stated. So it was all to do with a letter of credit, and there was an obligation on UniCredit to make payment under the letter of credit to Celestial. So essentially, it was a payment obligation from one entity in the company in the EU to another company in the EU. The letters of credit were there in connection with various leases of aircraft which had been provided to two Russian airlines. And so that's how the obligation to pay came about. Now, what the court had to grapple with was the meaning of a very particular regulation in the Russia regulations, Regulation 28.3c. And what it really turned on is, well, what level of connection did you have to have between the movement of the funds in question and the underlying arrangements which the letters of credit gave rise to? Now, Celestial Aviation said, well, look, hang on a second. All that's really happening here is that money's moving from one EU entity to another EU entity. What has that really got to do with the purpose of the Russia regulations? There's no way in which the Russian regime or the sanction parties are going to benefit from this. So they said, actually, you have to have a clear causal connection between the movement of funds and the underlying objective of the regulations. And they said, well, that isn't made out. On the flip side, it was said, well, look, actually, that's just too specific. You can't read to that level. And actually, you need to sort of take it at a far higher level and ask yourself, well, what is the broad purpose of the Russia regulations? And to some extent, unsurprisingly, the Supreme Court accepted that. And what the Supreme Court said is, well, you first start out by looking at the statute instrument, the regulations, and you say, well, what was the purpose of Parliament in passing these regulations? And the language within the regulations was the purpose of them is to put pressure on Russia. And so the court said, well, look, that is a very broad foreign policy objective, and it is not for them, as the court, to somehow narrow it down or read into it language which isn't present on the wording of the regulations themselves. And they said, therefore, it's not necessary to show that, for example, payment might somehow benefit the Russian regime. They didn't have to go that far. All you had to show was a very sort of low-level connection between the movement of funds and essentially the arrangements. And they said, well, look, really, the arrangements in question, the very reason why you had this letter of credit was to enable the Russian airline to get a lease over the aircraft. So actually, that's all that's required, something very, as it were, low level. And the court said, well, does this lead to a harsh result? And they said, well, yes, it does. But the mitigating measure is the licensing regime. So in essence, if there was a view taken that actually the payment of funds is an activity which ought to be licensed, the remedy, as it were, was for that party to go up to OFSI to seek a license. So it's not, I would say, an unsurprising result. And the Supreme Court's view is consistent with another Supreme Court decision, the Schvidler case, which was to do with designations of individuals on the sanction list, where the court there again emphasised that sanctions legislation is a foreign policy tool, and therefore, to some extent, they're in a very different bucket to other types of legislation which a government would pass. And it's the sort of arena where the courts understandably will give the government a large amount of deference and, I suppose, space in terms of how the legislation is interpreted. So that's Celestial Aviation. Another decision which I think has been an interesting one is a EuroChem decision which came out in July 2025. So it's EuroChem and SocGen, and HSF successfully appeared for HSF, and it was all to do with the payment under various bonds. EuroChem, as some of you will know, is a Russian company that essentially is involved in the agricultural industry. The founder of it was Mr. Melenchenko. He was then sanctioned. Steps were taken to remove him from the corporate structure of EuroChem. So the point being, certainly in formal level, it was said, well, look, he certainly has no ownership of EuroChem, but he has no control over it, and therefore the banks ought to pay out under the letters of demand. So the court was asked to consider a number of questions. First of all, they considered the knotty issue of control. Well, did Mr. Melenchenko still control the companies, notwithstanding the governance structures in question? Essentially, it was a question of evidence, and the court, interestingly, they went through all the case law, and there's been a lot of case law in the UK court as to how you apply the control test. And the court said, well, this is all very interesting, and it's clear from the case law that this is a very complicated question. But the court said, happily for the court, it was very straightforward for the court on the evidence that they had. And essentially, the court said, based on the evidence they had heard, that the witness evidence that was provided on behalf of EuroChem was not reliable, and the court made a number of sort of eviscerating comments. So they heard from the protector of one of the trusts, which ultimately owned the shares in EuroChem, and the court said that that individual was neither honest nor reliable. Another individual who'd provided a witness statement was a director of the trust, and the court noted that having made the witness statement, Mr. Noble then declined to give evidence. He was only then forced to do so after a letter of request was issued by the claimant, so he gave evidence remotely from Dubai. And the court then said in his oral evidence he was combative, evasive and obstructive. So really the control question just fell down to an evidential question, namely on the oral evidence before the court, whose witnesses did they prefer? And essentially the court was very clear that they did not find the witnesses of EuroChem reliable or honest. So on that basis, the court found that actually Mr. Milenchenko did still control the companies. So they fell down on that. But the court said, even if that wasn't an issue, the court said it was entitled to rely on the decisions that had been made by the national competent agencies in both Italy and in France, where essentially the bonds had been frozen. So the court said actually SocGen were right to say that actually paying out on the bonds would be an unlawful act because they'd be acting in contravention of the decisions of the national competent authorities. And as part of the illegality argument, the court had to then consider how does one analyze this question of illegal performance where what you're referring to, what you're dealing with is a payment under a letter of demand. Now, as you may know, where it's a simple debtor-creditor relationship, the default rule is the place of performance of the payment obligation. It's where the account of the creditor is based. And the claimants are saying, well, look, actually, our account is held in Moscow, where all we're insisting on is a euro payment in Moscow. Payment would not be unlawful in Moscow, and therefore performance is not illegal. And the court said, no, that's too simplistic. Unless there's an express contractual term, then actually the court's entitled to look at the facts in their entirety. The court said, actually, the key performance here, depending on where the demand was made, and the demand under the bonds was made respectively in France and Italy, and the question was whether payment would be illegal in France or Italy, and based on the particular EU regulation and indeed the position of the national competent agencies in those countries, it would have been illegal to perform the payment obligation. And the court said, well, even if the court was wrong on that, which it concluded it was not wrong, there was another interesting argument that the banks made relating to this notion of comity. And as you know, comity is a sort of an interesting but slightly abstruse principle that, in essence, between two foreign states, to some extent, there ought to be, depending how they're aligned, one court should respect the legal framework of the court in another jurisdiction. And the court said, well, look, even though we're dealing with EU regulations, actually, if you look at the language and history of the EU sanctions regulations, they're very similar to the UK sanctions regime. And they said, secondly, the purpose of the EU sanctions regime vis-a-vis putting pressure on Russia, again, is very similar to the purpose of the UK sanctions regulation. So the court said, if they were wrong in terms of saying that performance would be illegal, the court would have still found in favour of the banks under this principle of comity. And although it was dealt with in a few paragraphs, I think that's actually a really interesting determination that the court has made. And it's one of those areas which actually I think is of huge importance and interest to sanction practitioners. There's been very little case law on it to date. And no doubt it will be explained and evolved further over time. But it was a very interesting finding that the court came to. As I understand it, EuroChem are appealing that decision, and certainly on the Court of Appeal case listing database, the appeal is due to be heard in November. So it may well be that the last word of the Court of Appeal is different to that of Mr. Justice Bright. But certainly so far, the decision is a very strong and favourable decision for parties who are in a similar position to SocGen and ING, namely where a party does not want to perform a payment obligation for fear of falling foul of the sanctions regime.
Thank you, Saima. So now our turning to the Russian side and what can be done in Russia. In particular, we'd be interested to hear about is it Lugovoy? I'm gonna pronounce it incorrectly, but the Lugovoy Law and what effect that has had.
So I will start with a very shortly recap regarding the Lugovoy Law, and then I will proceed to the types of strategies that have been developed by the foreign countries in dealing with that. The essence of the Lugovoy Law is that the Russian party, even bound by a jurisdiction clause, be it an arbitration clause or a prorogation clause, may effectively ignore these clauses and bring the case to the Russian court, provided it is a sanctioned party and it has obstacles in receiving justice abroad. And both criteria are interpreted very broadly. So as far as sanctioned party notion is concerned, the Russian courts often do not require that these are the personal sanctions, so they don't require that the person is included in their relevant SDN or is owned or controlled. So very often the courts qualify also sectoral sanctions as sanctions. So the party may say, well, I'm personal sanctions, but there are sectoral sanctions that prevent that make me effectively a sanctioned person. And the second criteria, obstacles to in access to justice, is also interpreted very broadly. So actually, it may be enough for you to say that I will lose in the proper forum, in the forum mentioned in the jurisdiction clause, because that forum would apply sanctions, or it would apply the sanction clause in the contract. I would lose, so I don't have access to real justice in the forum according to the jurisdiction clause. That is why I'm bringing the case to Russia, and Lugovoy Law allows the Russian court to accept jurisdiction over this case, and this jurisdiction is exclusive jurisdiction of Russian court, so it excludes all other jurisdiction. And also Lugovoy Law allows a Russian court to pass anti-suit injunction preventing litigation or arbitration according to the jurisdiction clause. And apart from the anti-suit injunction, arguably also anti-suit injunctions and anti-enforcement injunctions may be may be granted as well, and these injunctions can apply both to the future and to the pending proceedings. And apart to the anti-suit injunction, Russian court can also apply a penalty. The penalty may be as high as the whole amount in dispute. So actually that sorry that penalty may effectively double the exposure. So there is a risk that a judgment will be enforced, and apart from that, a penalty may be recovered as well. So in essence, the Lugovoy Law allows bringing proceedings in Russia, notwithstanding the relevant jurisdiction, arbitration, or prorogation clause. It allows to restrain the foreign defendant in proceeding with or in initiating the arbitration and litigation. It provides for penalties, and also once you have got a Russian judgment, you may enforce the Russian judgment abroad and also in Russia. And we see a number of we see a very large number of cases where Lugovoy Law was applied. So actually it looks for the Russian parties, it looks like a very attractive way of protecting their alleged rights. And so there are several hundreds of cases heard according to Lugovoy Law. And there are also a number of instances where the judgments rendered according to the Lugovoy Law, they were either enforced in Russia, or at least the assets were arrested, securing their future enforcement. So actually, the litigation according to Lugovoy Law is not a theoretical risk. Well, practically for the Russian parties, sometimes it's their only way to get a judgment in relation to the right that they think they have, notwithstanding the sanctions. And after this recap, I'm moving to the possible strategies that the foreign parties have developed in relation to to dealing with this Lugovoy litigation, and actually their choice between the approaches depends on their situation. So the first approach is the recourse-based approach. So it is the situation where the defendant is actually not the ultimate payer, but it has a right of a recourse against someone else. So, for instance, it may be a bank guarantor who has a right of a recourse against the principal, or it may be a right of recourse against the insurance company. And in this case, the main purpose may be not to lose the right of recourse and not to make anything that would make it possible to object regarding the recourse claim. So in such a situation, foreign companies fully plead their position both on jurisdiction and on the merits, because if they don't do so, the party against whom the recourse is sought may say, well, okay, you lost this case because just you were conducting it not in a proper way. That is why we shouldn't be liable for your recourse claim. And in order to avoid it, you need to fully plead your case. And regarding on the law applicable to the recourse claim, it is also necessary to consider whether coordination is required with the person against whom the recourse would be sought. What should be the extent of some coordination, whether it should be coordination in advance or whether it should be just a post factum coordinations, and so on. And in these cases, in the recourse-based approach, foreign parties often prefer not to obtain any anti-suit injunctions, because if they obtain the anti-suit injunctions, for instance, in the English court or in some European court, then they may be countered by anti-suit injunction. A penalty may be ordered, a penalty may be potentially recovered, and as opposed to the main sum of the debt, there is a high risk that the penalty could not be included in the recourse claim. It was the first approach. The second approach is often applied by the parties who are the ultimate payers. So if they don't have anything against whom they could seek their recourse. So in this case, first, the jurisdiction objections should be raised anyway, because according to Russian law, not raising the jurisdiction objections qualifies as submission to jurisdiction. So even if you have some jurisdiction clause and you don't raise the objections, you are deemed to have accepted the jurisdiction of the Russian court. And as far as pleading on the merits is concerned, so there are two counterbalancing considerations. So the first consideration is that pleading on the merits may theoretically be considered as submission to jurisdiction. It's very important to note here that according to Russian law, pleading on the merits does not qualify as submission to jurisdiction. You may file jurisdictional objections. If you lose them, you may still reserve them. You may plead on the merits. Then you can raise the jurisdictional objections in appeal, in cassation, in the Supreme Court. So according to Russian law, pleading on the merits does not qualify as submission to jurisdiction. Nevertheless, some parties are afraid that in foreign courts it will be still qualified as such. Other counterbalancing objections is that by enforcement abroad, many parties may want to refer to a number of concepts, something like violation of public order, a lack of fair trial, and so on. And in order to successfully invoke these concepts, you need to plead on the merits. Because if you didn't plead on the merits, how can you say that your right to a fair trial was violated? So these are the arguments, these are the considerations that are important for the ultimate payer to decide whether to plead on the merits or not. And also, obtaining anti-suit injunction depends on whether you really expect that the Russian party will comply and whether you have any assets, because again, anti-suit injunction may trigger anti-suit injunction from the Russian court and may trigger penalty that may double your exposure. And the third approach is passive approach to litigation. So it may be applied in smaller cases where you really don't expect any enforcement abroad. So the parties either limit their involvement in jurisdictional objections or just don't appear in the court at all. Whereas it may be an acceptable approach, you should be very cautious here, because if there are some assets in Russia, you may lose much more than the judgment, because assets may be arrested in the sum that may very well exceed the sum of the judgment. So it may be 2, 10, 20, 30 times. So, for instance, the bailiff arrests your whole account. And also, if the assets are sold on a tender, it may be at an underprice. And the third, although the judgment may be relatively low, it may still trigger the local insolvency of the relevant Western company in Russia. And I think Nikolay will deal with the local insolvency a little bit later at the end. So thank you very much.
Thank you, Oleg. That's a really interesting overview of the Lugovoy Law, of the different approaches that you can potentially take in Russia. There's definitely a lot to think about there. You know, do you want to challenge jurisdiction, the points on the merits, or do you want to be a little bit more passive? But of course, for international companies, Russia is maybe only half or part of the picture. There's also the question about what do we do, what should we do, what can we do in England? Should we seek international relief, or are there any other options? Alexander, I think you're going to speak to that.
Sure. Thank you so much, Emma, and thank you, Oleg. I think picking up on what KK&P have just said, once the Russian proceedings are commenced under Lugovoy Law, I think the international defendant is faced with a very serious strategic question as to what to do and how to react, basically. And speaking from experience, it's not simply a question of the best legal advice or which legal analysis is correct. It's more of a strategic decision and of weighing a large number of commercial, procedural, tactical, and enforcement factors as well. And KK&P have just spoken about the three routes that can be used in Russia, whether to challenge jurisdiction, whether to fight on the merits, or whether in some situations the best thing is actually to leave the proceedings altogether. But there is another layer of complexity, because the English courts can also assist the international companies. And as Simon mentioned, the English courts have not been passive in trying to police the enforcement of the exclusive jurisdiction clauses or various jurisdiction clauses, arbitration clauses as well. And I think the most well-known instrument for the English courts is actually the anti-suit injunctions. But in this area, the toolkit has become much broader and more prominent. So we're now talking also about the anti-enforcement injunctions, where the English court restrains a party from enforcement a judgment obtained in breach of an agreed forum. Also talking about the anti-suit injunctions, where the English courts restrain a party from seeking to rely on the Russian anti-suit injunction, which was originally obtained to stop the English proceedings. And we're also talking about declarations, for example, declarations of non-liability or as to the effect of sanctions. And I guess the extent of the toolkit, it reflects how the disputes on sanctions have evolved, because historically the question might have been very simple. A party has sued abroad in breach of an English arbitration clause or jurisdiction clause, and should the English court stop that? And an ASI was often a very relatively straightforward answer to this. But in the Russia sanctions context, the position now is much more complex. And a simple example is that, and I think, Oleg, you've already mentioned that, if a Russian party starts proceedings in Russia, the international company can respond by considering an English ASI, but then the Russian party can respond with a Russian ASI requiring the defendant to stop the English proceedings or arbitration, and that would be backed by very substantial penalties, which would then be enforced against the Russian assets. And so the question, from my perspective, is not just can we get an ASI, because most of the time, often, the answer would be yes. And the real question now is, should the international clients actually get it or not? Because there obviously have been a number of recent decisions in England about anti-suit injunctions and anti-anti-suit injunctions. Just to name a few, the Barclays cases, Renaissance Securities, Magomedov as well. And I don't propose to go into those in detail, but the overarching point from these cases is that the English courts are very happy to police the enforcement of the jurisdiction clauses and to protect the parties' agreement on jurisdiction and arbitration. But I think one case in particular requires some attention, and that is the case of UniCredit and RusChemAlliance, because that was an interesting case from the strategic point of view. There, UniCredit obtained English anti-suit relief, but then the Russian court actually issued its own order requiring UniCredit to take steps to cancel an English ASI or face a penalty of 250 million euro. And not surprisingly, UniCredit went back to the English court and asked to discharge the injunction. The Court of Appeal found jurisdiction to do that and discharged the injunctive part of the order, leaving the declarations aside. That's a separate question. But the injunction was discharged because of the commercial reality of the situation, because obviously UniCredit didn't want to face such a significant penalty. And that, I think, highlights the difficulty that international companies are facing. It may be theoretically possible to obtain an ASI, but if the Russian response is a very large penalty, then the ASI may create more risk than it removes. On the other hand, and from that perspective, the advisors can face a very uncomfortable situation where the best advice to the client is to do nothing in England, or at least not to escalate by getting an ASI, despite the fact that the client might have every chances of success of getting an order here in England, but commercially it just might be too risky. Of course, the situation is different if the defendant doesn't have any assets in Russia, and in that case, the Russian penalty is not that scary, so to say. But maybe in that situation, the strategic decision could be, yes, it may be worth obtaining an English ASI because it creates a good record. It confirms the English court's position that the jurisdiction is actually with the English courts, and then maybe that can be used in the case where the Russian judgments obtained under Lugovoy Law will be enforced somewhere abroad, and the argument about English court jurisdiction could have more weight. But that, I think, brings me to the second question about the Russian claimant already obtaining the judgment. And the question is that the end? Does the story end in Russia? And again, the answer could depend on the asset position or the exposure of the defendant to Russia. If there are significant assets there, then obviously the first point of recourse is actually go against the Russian assets and enforce the judgment against them. But many companies have reduced their footprint in Russia, and there are at the moment, many of them don't have sufficient assets in the jurisdiction. And so obviously for Russian claimants, the idea would be just to go and enforce elsewhere in other jurisdiction. And this is actually not theoretical, because we have already seen Russian parties and Russian insolvency office holders trying to test enforcement and asset freezing routes outside Russia. One good example is a Russian Google case where Russian insolvency practitioner tried to enforce in South Africa and obtained a freezing injunction there. Another example, and I guess that was the same insolvency practitioner, tried to go in France and do the same, probably less obvious jurisdiction. But then EuroChem case is another example where steps were taken in India. And the precise procedural situation around those attempts is not always clear because the media reporting is patchy. But I guess the overarching point is that the risks are not theoretical. Russian parties are actually going somewhere else outside Russia and try to enforce rather than just staying within the Russia borders. And then the question would be, where would they go? And that's not an easy question to answer because it will depend on many factors, including where the assets are. And the geopolitical context also matters because you would expect the Russian claimant to look at jurisdictions that were culturally, historically, geopolitically connected with Russia to be the first point of recourse. And then the legal map as well. How difficult is the enforcement in the jurisdictions where the claimants might actually go? And obviously, the requirements are different in many jurisdictions. We have common law jurisdictions, civil law jurisdictions. Some of them have treaties or international arrangements with Russia, which could make the enforcement of Russian judgments easier. And some good examples are mainland China or Turkey. And those jurisdictions have those arrangements. India, for example, doesn't. So the way for the Russian claimant to enforce there would be much more difficult because you would need to bring a fresh claim. And then you would obviously need to consider to what extent the international company would be able to fight against that enforcement. Most jurisdictions would not reconsider the cases on the merits, so you won't have a second bite of the cherry. But the jurisdiction arguments can be brought, and specifically, I think the Lugovoy Law is particularly could be the area where the international companies can base their jurisdiction arguments on, because that is not an obvious way for the Russian courts for the international courts to accept that the Russian court has jurisdiction, and you could probably claim that it wasn't a good argument for the Russian court to do so. And there's also this geopolitical dimension, because it is probably tempting to think that about the jurisdictions that are geographically or historically related to Russia, like Kazakhstan, for example. But that can be misleading because we have seen examples in Kazakhstan specifically where on politically motivated cases, Kazakhstan refused enforcement of Russian judgments. So it's not automatic there as well. And finally, I think that also affects the position on English ASIs, because if you know that the enforcement will be attempted in England, which is probably unlikely, then it's obvious that English relief will be very powerful. But if enforcement is attempted elsewhere, then there's a question to what extent an English anti-suit injunction or anti-enforcement injunction will be powerful. And in most jurisdictions, it will not operate as an automatic bar because the local court will apply its own recognition rules. But in common law jurisdictions, it may have some persuasive force. So it may make sense to obtain an English ASI just to prevent some attempts to enforce the Russian judgments in those jurisdictions. Whereas in the mainland China, I'm not sure that the English ASI would be actually persuasive. Maybe it will help, but it's less obvious compared to Hong Kong, for example, or Dubai, DIFC. I guess all of that brings us to a strategic conclusion in a way that the position is much more complex than it was before 2022, and it's much more complex than in ordinary cross-border disputes, because, as I mentioned, the English courts have strong tools: anti-suit injunctions, anti-enforcement injunctions, anti-enforcement injunctions, declarations. So the toolkit is quite significant, but the existence of those tools is often not the end of the story and not the end of the inquiry, and the inquiry is much more complex and often would require consideration of many factors, commercial, procedural, tactical, and often that would require strategical contribution from many sub-teams within the client and sub-teams within advisors, and including by anticipating where those global proceedings might go. Thank you.
Thank you, Alex. So we've heard quite a bit now about what the Russian courts are doing, what the English courts are doing, and there's a lot of strategic points to think about. I think, Nikolay, you're going to follow up with some of the more recent trends in Russia in terms of enforcement.
Yeah, sure. Thank you, Emma. Hello, everybody. So I'll talk about the emerging trends here in Russia, because on the one hand, as Alexander said, now the Russian claimants and the foreign defendants, they just have to focus on geography, they have to focus on the local regulations, and to create a truly complicated map of the world with the structure of the regulations all over related to the assets. And this is a task, I will say, for both parties in such conflicts, for the claimants and for the defendants. However, there are some internal trends in Russia which may affect the general strategy for the Western defendants in the upcoming years or maybe even months. So the first trend is that Russian creditors have to focus on foreclosure of the latent assets, such as receivables, and avoiding local bans on foreclosure of the blocked assets. I mean, the Russian anti-sanction regulations which frozen the Western companies' assets in Russia. So the position with the enforcement of Russian judgments obtained via the Lugovoy Law is becoming more complicated, even in Russia. Many Western companies have reduced their Russian footprint. They may no longer have an ordinary account, operating assets, or other obvious targets for enforcement. That's why Russian claimants are increasingly looking for other forms of value, including receivables owed by Russian counterparties to the foreign companies, funds that should be paid to Type C or Type P, blocked restricted accounts, already blocked securities or funds, shares or interests in Russian subsidiaries. It's interesting that the Russian central bank keeps protecting such blocked accounts from foreclosure, even from foreclosure in favor of the Russian major state banks. In some cases, the Russian central bank directly objects the relevant court claims, even if such claims are presented by top 3 Russian large state banks supported by the prosecutor. And in our experience, this contradiction between the Russian bank, central bank interest, and the state bodies, including the prosecutor general, creates quite a good space for battle, and this may be used by the foreign defendants via involvement of the Russian state bodies in their proceedings, making their fight with each other. It's quite a puzzling situation for the Russian judge when, on the one hand, she see a great Russian bank and a prosecutor general, and on the other hand, she see a central bank of Russia objecting their claims, and the best solution in such a case for the judge is to postpone the hearing as far as it's possible and to wait for final resolution of the political issue. However, the courts have started to support some attempts to avoid the local restrictions on assets. For example, there is first and appeal instance court practice allowing payments to a creditor's regular, not a Type C, but general, regular, not blocked account if the foreclosure on a Type C receivable is made by the bailiff. For example, if there is a claim of a foreign defendant against a Russian debtor, and such a foreign defendant will try to assign the right of claim to another Russian entity, then such new Russian entity would anyway get the payment on Type C account. So it's quite hard to avoid the restrictions if the receivable is doomed to be paid to a Type C account, then assignment wouldn't have. However, nowadays the court's starting to say that if the Russian creditors foreclose this right of claim, this receivable, through the bailiffs, then they are able to get the money not to a Type C account, but to a regular account. So it's not a Supreme Court position. It's not a common established trend, but we see that there are ongoing attempts of the Russian creditors to find at least something in Russia which may be foreclosed on the basis of Lugovoy judgment, and sometimes the court are happy to support them. So it's like cats and rats. Like the cats are looking for the rats, and the rats are trying to just go away. So the second trend is that now the claimants are trying to avoid references to Lugovoy law in order to increase chances for recognition of Russian judgments abroad. So it's very easy to get the Russian court jurisdiction if this issue is considered by the Russian court. The Russian court will accept the jurisdiction, but the main problem and the main question is what can be done with the judgment abroad. And since the parties, as we discussed a minute ago, faced problems with enforcement of such judgment abroad and in Russia, even in Russia, now they're trying to say that effectively the Russian claimants try to avoid express references to the Lugovoy law. They frame the claim as a tort claim and rely on the old classic procedural provisions of the Russian courts, which has nothing in common with Lugovoy law, like 30 years old law provisions. And they are saying that as far as the harm occurred, and this harm occurred in Russia because the Russian claimant didn't receive any payment, then due to old Russian procedural provisions, the Russian court should accept its jurisdiction. The objective of this trick is to produce a Russian judgment that looks like less like a Lugovoy law judgment and more like an ordinary commercial judgment which may be enforced abroad. But this is not a perfect solution for the Russian claimants, since the crux of the issue is pretty much the same. So such judgment still violates arbitration clause, prorogation clause, and it still violates New York Convention, even if no direct references to Lugovoy law are included in the judgment. So, moreover, even from the Russian law procedural perspective, such justification is quite weak. The references to tort under the relevant Article 247 are relevant in absence of arbitration and prorogation clause only. If such clauses were included in the contract, then literally under Russian law, this trick is not applicable to the case. It's much more complicated when there is no a direct contract between parties, like when there are chains of payments or when there are chains of structured relations between the parties, and when the claimant doesn't have any direct prorogation or arbitration clause with the final defendants. This makes some space. It gives some space for speculation regarding the tort claims and jurisdiction of the Russian court on the basis of this argument. However, usually we have a good space for discussion in this respect, and these arguments may be presented to the foreign court as well at the stage of recognition of the judgment, saying that, look, even under the Russian procedural rules, it was a gross breach of the jurisdiction grounds. So the third trend is that Russian creditors start to consider insolvency as a last resort and a new route to enforcement abroad. The risk of insolvency of the Russian subsidiaries is quite well known and well predicted. Moreover, it seems that most Western companies have already tried to mitigate this risk. We may speculate about effectiveness of such mitigations, because in some cases the Russian subsidiaries were liquidated. In some cases the Russian subsidiaries were sold to the local buyers or to the managements of the companies. The effectiveness of such mitigation is a very interesting contradiction point. But as a spoiler, the later sale of the entity doesn't help to avoid liability within the insolvency of the sold entity. This is a very big problem. So it's not the end if you sold your subsidiary company. But today I want to focus on other problem. I will focus on the risk of the foreign companies' own insolvency in Russia. So even if they have no and never had any Russian subsidiary, even if they operated directly from the European or American territory in Russia, still since 2024, after the Russian Supreme Court position, such companies are under the risk of the insolvency proceedings against them in Russia. The test for such insolvency is very broad. Now, while initiation of the primary main insolvency proceedings is quite complicated because it requires a very strong connection with Russia, Comity should be strongly connected with Russia. At the same time, it's quite easy to initiate the secondary insolvency proceedings. For example, in several cases, the mere presence of receivables in Russia was recognized as a sufficient ground for secondary insolvency proceedings. Like a foreign company has a claim against a Russian debtor, and that's enough. It's a good ground to start the secondary insolvency proceedings against such a foreign company in Russia, because the right of claim receivable is an asset which may be recovered for close the territory of Russia. So let's keep the procedural nuances and focus on the practical essence of the issues of this issue. There are hundreds of insolvency cases against foreign debtor commenced in the previous 2 years, hundreds. But there are almost no big cases against prominent defendants. So why? Hundreds and hundreds. They are trying again and again. The tax authority of Russia initiates it in a half of cases, but we see no significant cases against really big, for example, banks, Western banks. The reason is that most Russian creditors consider the insolvency option as a last resort, because it entails not only benefits for the creditors, but some significant downside also. So on the one hand, the benefits are as follows. First of all, it allows the creditors to get an enforceable judgment not only against the contractual debtor itself, but also against its affiliates, shareholders, UBO, against its management, and even against the major counterparties of the debtor. Thus, shareholders and management may be brought to subsidiary liability, which means, in simple words, the whole amount of the debts of the debtor, which may be imposed on the management or shareholders and UBO of such debtor. And the transaction of the debtors with its counterparty, intragroup transactions including, may be challenged within the very specific rules of the Russian insolvency law. Believe me, it's quite a specific and effective mechanism. So what does it mean? In both cases, the insolvency judgment would imply recovery, and accordingly, such judgment potentially may be recognized and enforced abroad as simple recovery judgment, not against the contractual debtor itself, once again, against the wide range of the entities and persons linked to the contractual debtor. So this is very sensible for the creditors if assets of such affiliates are located in Russia or other jurisdictions where the enforcement is possible. So recognition of the Google case judgment is a good example of this. Even quite a politically affected case of Google has a good chance to be recognized, at least in South Africa, maybe in France at the moment the interim relief in support of such recognition was accepted by the French court, so potentially, it's possible. So the second benefit for the Russian creditor to start the insolvency proceedings against a foreign company is that they are trying to use this as a route, as a way to solve the enforcement issue of the Lugovoy Law. Because Russia is a more natural jurisdiction for insolvency proceedings. You see, the breach of arbitration or prorogation clause on the basis of Lugovoy Law is purely a political step, while the insolvency all over the world is a natural reason to ignore dispute resolution clauses with no any political context, just because this is insolvency and all the disputes should be considered within the insolvency case. And such a natural ground to ignore the arbitration provision, the prorogation provision, significantly increase the risk of enforcement of such insolvency Russian judgments abroad, which may be a good route for the Russian claimant and a big problem for the foreign defendant. So the third reason is quite specific, but still we should consider this, that the Russian insolvency may be a route to bypass contradictions between the creditor and the Russian bailiff during the enforcement. As we discussed, it's a big problem to find the good assets to be recovered in Russia now. And the Russian claimants, they have to force the bailiff within the enforcement proceedings to consider an option to foreclose on blocked assets, to get a presidential permission or central bank permission to do anything. And sometimes we see that it might be a deadlock between the creditor who is trying to seek the enforcement and the bailiff who is actually don't want to do anything. So she just wants to be alone, far from the creditors. So in such a case, it may be a good solution for a deadlock between the creditor and the bailiff, just to skip this, to start the secondary insolvency proceedings and try to make the same trick with support of the insolvency receiver and the Russian court considering the insolvency case. So on the other hand, the Russian secondary insolvency has significant downsides for the creditors. So that's why we don't see hundreds or at least dozens of the insolvency cases against big debtors. So first of all, the insolvency may require 2-3 years, which is longer than the ordinary enforcement proceedings, even longer than recognition and enforcement in some jurisdictions. It's a downside. Secondly, most likely, in case of insolvency, other Russian creditors will join the proceedings as well. Accordingly, the active creditor who is seeking for recovery will have to share the revealed assets with all other Russian creditors within the scope of the insolvency proceedings. And of course, his interest is to bypass his competitors and to get the recovery ahead of them. But in case of insolvency, it will be really hard to do. So the third downside is that even partial payments made in favor of such active creditors in advance of the insolvency, 6 months in advance, may be challenged as a preferential transaction. What does it mean? Look, you as a creditor, you have successfully foreclosed at least part of the debtor's assets, and then you start the insolvency. So the amount effectively foreclosed 6 months in the past may be turned back from you as an active creditor to bankruptcy estate. So it was a nice celebration party regarding the recovery. You were happy. You saw that at least partially you or your client received satisfaction. But no, this amount will be transferred back to the bankruptcy estate and it will be shared between all the creditors. So this is a kind of a downside. At least they need to wait, for a while since the actual recovery till start of the insolvency to be out of the challenging period. So the fourth downside is that conclusion of the insolvency proceedings may lead to the full discharge of the debtor's obligations before the Russian creditors. What does that mean? Let's imagine that the insolvency proceedings have started. It lasts for years. Eventually, the receiver failed to recover anything. And as a result, the procedure will be finished with no actual satisfaction of the creditors. Now, in normal situation, in absence of the insolvency proceedings, it will be a good option for the creditor to at least try to recognize and enforce the judgment abroad. But in case of insolvency, such conclusion of insolvency proceedings may lead to discharge of the debtor obligation before the Russian creditors. So it's maybe like, a final step, a final attempt to recover, because otherwise it's quite possible that after the insolvency proceedings, the creditor will not be able to try to recognize and enforce the recovery judgment abroad, because all obligations are discharged. To be honest, there are some contradictions in this respect regarding the formal procedural grounds regarding termination. So the general idea is, this is a risk. Sometimes obligation may be discharged in full. Sometimes those obligations will still have a place even after the insolvency proceedings. So, by default, a creditor would avoid starting the insolvency of the foreign debtor. That's what we see now, and now you understand why. However, if he sees that there is no other effective means of recovery left, then the insolvency will be the last resort for him. So, finally, you may ask, what does it mean for the Western debtors of the Russian creditors? Just 6 points. First of all, if you consider the relevant risk as significant for you or your company or client, we recommend preparing the evidence in advance of the actual filing of an insolvency petition by a creditor. So you shouldn't wait. Why? The insolvency procedure may be introduced as early as 1 month after the foreign company becomes aware of the insolvency, after filing of the petition for insolvency. For the Russian tax authority and Russian banks, there is no an obligation to get a recovery judgment first. So in ordinary situation, you will see that there is a long litigation proceedings where the creditor will seek for a recovery judgment, and only after this long proceedings, the creditor will initiate the insolvency. But the tax authority is not obliged to get a judgment, recovery judgment. The Russian banks, and there is a supporting practice, are not obliged to wait for the recovery judgment. They may start the insolvency proceedings directly on the basis of the receivable. So there is no need for them to get a prior recovery judgment, and so it may be a very swift and unexpected process for the debtor. Moreover, in 70% of cases, there is no warning notice in the public database regarding intention to initiate the insolvency. So by default, to the Russian debtor, there is a rule that it should be a formal notice prior, 1 month prior to the insolvency. It's not applicable to the foreign debtors. In 70% of the cases, there is no any publication, and the courts are fine with that. They would initiate the proceedings. So it means that if there is a significant risk of a potential insolvency, we recommend to prepare the defense in advance, because otherwise it may be just not sufficient time, to do anything. So secondly, we suggest considering the applicability of the EuroClear defense to your case, which effectively allowed EuroClear to avoid insolvency in Russia in 2025. It was an attempt, but eventually, with support of Central Bank of Russia, EuroClear proved that there are no sufficient assets in Russia to start the insolvency proceedings. So EuroClear showed that all of the assets are the third-party assets, and EuroClear is acting as a nominee holder for the great majority of the shares and money in Russian accounts. So formally, EuroClear as a holder, it holds a huge amount of money and assets. But all of these assets belong to the beneficiaries. They belong to the third party. And accordingly, those assets are not subject to recovery in order to satisfy EuroClear own debts. And that's why those assets are not the ground to initiate Russian secondary proceedings. So it was a quite effective defense, which may be considered by other debtors in Russia. Thirdly, we suggest considering the blocked assets defense, which means that blocked assets like Type C, Type I accounts cannot be recovered due to Presidential Decree 95. And presence of such assets is not a ground to initiate the Russian insolvency proceedings. There is a space for discussion in this respect, whether the claimant will say, the petitioner will say, that formally it's not prohibited to locate restricted assets in the bankruptcy estate in case the permission by the president of Russia or central bank is obtained. So if potentially it's possible to locate the assets in the bankruptcy estate upon receipt of the approval, then the insolvency case should be started. So this is a potential logic expected from the claimants in such cases. Still, we see quite good arguments to prevent initiation of the insolvency proceedings in such a case. So, firstly, even if the insolvency is commenced in Russia, the foreign debtor may be interested to preventing below market price sales of the debtor assets, because it's a very big problem. You may have huge assets in Russia, but Russian insolvency provides the receiver and the creditor with quite good practical mechanism to make a low price sale of the quite good assets, which effectively will mean that the amount of the debtor debt will be decreased not so strongly in comparison with the actual loss of assets. Like you have a 1 million receivable against the Russian debtor, but effectively this 1 million debt will be sold for 1,000. And this is a very big potential problem. Fortunately, there are some quite effective ways to prevent, to protract such attempts, including challenging the procedure of asset sale, challenging the assessment, challenging the results of auction. The point is that this process should be controlled, because you may be in the situation when all the Russian assets were foreclosed, but amount of your debt is pretty much the same as it was, and subsequently they may try to recover it twice, which will be quite a bad outcome of the situation. So fifthly, the debtors' affiliates are not doomed. So even if the damages claim, tort claim, or is filed, subsidiary liability, or the transaction is challenged, it's quite possible to prove that there is no harm caused by such transaction or decisions of the management to the debtor and its creditors. So it's quite a good space for the battle on the ground of the Russian court practice. So finally, the structuring and moving of the assets in advance of the insolvency is a very important step. However, we will prefer to discuss it in a small circle, because such steps sometimes may be challenged for various reasons. So, after all, it's quite likely that you will never face the Russian insolvency. However, if you do, we suggest preparing the strategy in advance and with respect to the risk of potential enforcement abroad. Such as enforcement will be quite unlikely in Europe, in the United Kingdom, but still the risk is relevant for the rest of the world, which is quite big. India, China, Middle East. There are a lot of regions where Western Bank has offices, or at least their debtors. And while the receivable is a target for enforcement, effectively all the world is under the pressure of the potential enforcement attempts. So, in this respect, Alexander, just wondering, what is the prospect of recognition of the Russian insolvency judgments here?
Thank you, Clay. I think that is a quite a complex question. I'm not going to say that I'm an expert in enforcement of insolvency judgments in the UK, but from what we have seen over the course of the past few years, there have been attempts to test the UK regulation on insolvency, and mostly in relation to individual insolvency. And there are also a few things happening on the corporate insolvency as well, but there's no guidance at the moment. And from what we can see, that may change because the Russian insolvency practitioners are really trying to test the limits in relation to the corporate insolvency as well. So I'm sure in a few years we'll hear more about this, and particularly given that what you've just said about the risks of Russian insolvency, that might well happen.
So there is a space for discussion here before the UK court about the possibility of recognition, and it might be some discussion regarding breach of sanctions by such recognition, so whether effectively, materially, such Russian insolvency was based on sanctions and relevant issue or not. So this may be the issue to be discussed as well.
Exactly. So many points. Exactly.
Great. Well, thank you very much, everyone. We've covered a lot of ground there, but it's all been really interesting.